Thanks, Jack. Normally this is the time for rebuttal or sur-rebuttal. I'm not sure that's needed here, but nonetheless.
Well, I would like to address just a few of the challenges and concerns you had. The first is, to what extent was the 14th Amendment secret? Because during the adoption of the Civil Rights Act, they were very emphatic about, I should say some were very emphatic. I don't think it was all that secret. The radicals were very overt. Horace Greeley's New York Tribune is very loud and vocal and is being republished over and over again. Radicals are during the ratification debates, radicals are challenging racial endogamy laws in the courts on the basis of there being violations of the Civil Rights Act. In this regard, I guess it would be important maybe to distinguish between motive, reason, and nonetheless general expectation. I want to say I think I'm getting expected application, a general sense of what the law would do. The 15th Amendment, I think it's fair to say, was not passed because Ohio Republicans, or I should say Ohio citizens or citizens in the North were really interested in looking forward to the prospect of the Great Migration North and for their states becoming, along down the road, places like Ohio and other states, Michigan, becoming blue states or even Democratic states, because these are all things that the 15th Amendment affects as a practical matter. 14th Amendment's right to travel, 15th Amendment's right to vote. And so the same thing is with the issue of interracial marriage. They weren't interested, the majority of Republicans were not interested in itself in making sure that interracial marriage was lawful. They were interested in getting a broad set of rights. But the problem is, if you choose a category that has a certain breadth, it's going to bring in a few other things, not accidentally, but that's just the way it goes. And that's one of the benefits and the burdens of the rule of law. When you put things into a rule rather than a regularly revised arrangement, you're going to get things that just the way you phrased them, you're going to have to accept along with the rest. Again, for some radicals, this was fine. The abrogation of these laws was something that they had been agitating about. It wasn't a secret design. Second issue is why is the common law somehow associated with the rights of citizenship? First, because common law defined the status of citizenship. Section 1 of the 14th Amendment, my estimation, was Republicans' effort to just simply rewrite a declaratory provision in the Constitution that the common law rule is now going to be the constitutional rule. And in many respects, the privileges of citizenship are defined at common law, not statutory law, especially the right to acquire real as well as personal property. Does Section 5 under this reading lead to, how broad would Section 5 powers be under this reading? I don't think that the 14th Amendment says you must give everyone common law rights. What it says is don't pass any or enforce any statutes that would abridge the privileges of citizenship. So first you take the common law, you find out what rights are there by common law, or I would say by the broader Anglo-American tradition, belong to citizenship. Things like arms bearing, freedom of speech, not religious freedom. Religious freedom didn't belong in common law. And then you say, okay, well, do we have any statutes hanging around that are reducing or contracting in a significant way these rights? And I think those statutes would include the racial endogamy statutes. I'm flirting with the idea that it would include statutes that overturned the common law rights of travelers vis-a-vis common carriers, thus giving some basis for the 1875 Civil Rights Act. But it's not, that it's still significantly broad, but you'd have to find a connection with citizenship, which is why I labor over this so much for so many pages. Because I don't think the right to marriage is protected by the 14th Amendment. I think what's protected by the 14th Amendment is the right to marriage only insofar as it's a privilege of citizenship. And for the most part, a right to marry, no one in the founding or the 19th century would have said that citizenship gives you marriage. Marriage comes first, civil society comes second. Lastly, about the pro-slavery reading, which I highlight, the antebellum pro-slavery reading. I suppose my argument would be, I don't think what they said was I don't think they were inflating what citizenship had already meant. The words privilege, immunity, citizen have a kind of neoclassical flavor to them. There's Latinate terms. Much of the founding era has a neoclassical sense of it. And to speak to educated, classically educated 19th century Americans and say, British citizenship and its privileges, that would include a right to intermarry with other citizens. And that's not something that the pro-slavery ideology came up with, or really all they did was simply highlight it. So it's the originalist, I should say, the terms of the Privileges and Immunities Clause, understood in a very deep sense in the broader Western civilization, but especially Western civilization as understood by 18th and 19th century Americans, would have saw some problem with racial endogamy laws.
Thank you, David. It's good to be reminded of the important and admirable role of Horace Greeley in that period, though there's the slightly eerie fact that fame and distinction that Greeley had lived on in, among other ways, in Hitler's finance minister, whose full name was Hjalmar Horace Greeley Schacht. He's not here to join us today. So my first trinity is Chris Green, Earl Maltz, and Randy Barnett. Chris.
I just had one really technical thing. In terms of explaining what's going on in 1866 between the Civil Rights Act and the 14th Amendment, you got to look at the committees that they come from. So Trumbull is Judiciary Committee chairman, and Trumbull is idiosyncratic. I mean, if you look at what he's saying about the Privileges and Immunities Clause in 1871, it is idiosyncratic. So I love the fact that he was a loyal denominatorist at one point, but he's idiosyncratic. Second, kind of broader thought is to B and to C with the proper kind of adverbial thickening. So here's one way you could do it. Privileges and immunities of citizens of the United States are the privileges generally given to citizens today. What the Privileges and Immunities Clause bans is inequality either among the citizens of the United States in one state or between the broad mainstream and the outliers. So then you have this equality reading, and you get both deeply rooted common law and statutory Bill of Rights stuff, and the stuff that Field thinks it means. Bradley joins Field's dissent, so it seems like you can get both of those.
Earl.
Just an observation on the question of the scope of the relation of Section 5 to Section 1. When Bingham proposes his first amendment, the first federal power amendment, 6 different Republicans complain about the potential scope of congressional power. None of them complain about the Privileges and Immunities Clause. They all complain only about the Equal Protection Clause, and some number of them, I don't have the number before me, specifically say that they don't have any problem with giving Congress the authority to enforce the privileges and immunities of American citizens. So now, where exactly that takes me in specifics, I'm not certain, but I think it's pretty clearly relevant with respect to original fill-in-the-blank, because we can argue what the blank is, about the scope of the privileges and immunities, which become privileges or immunities because of, in my view, maybe you might disagree, because of the necessity of the change in grammar when you guarantee them rather than, I know, I can't help it when you're wrong. So anyway, I just think that that's relevant, and I'll shut up then for once.
Randy.
I just want to say, David, I thought this was an amazing paper, a fantastic paper. Really learned a lot from it, and it was just really, really well done in the ways that Jack has already enumerated, with the kind of marshaling of evidence and the fair-mindedness with which it presents contrary evidence and tries to reach a balance. It's just very, very nicely done. And I do think it reinforces Mike's important work on the 14th Amendment. They do go together with each other, and it's very nice and welcome. And I only have a comment. I don't have a question. I don't have a criticism. My comment was sparked by Jack's concluding reference to Berger and how we need to somehow remember that these Republicans really weren't the kind of guys that Berger and Fairman were painting them out to be. And it was slightly influenced by Myman's reference to Lincoln. Because I think that even the reference to Lincoln itself underplays the degree to which this was a very robust constitutional philosophy that long predated Lincoln's change of heart or going from being a Whig to being a Republican. He was a very latecomer to this whole thing. Things had been worked out for 20 years before he came around, though he was a very nice spokesperson for this. And so I just want to emphasize that this also goes together with the work that I've been doing on abolitionist constitutionalism, which itself I think has largely been forgotten in favor of radical Garrisonian abolitionism, which is, they were all swimming in the same sea and they were hanging out together and they had a lot to do with each other. But these abolitionist constitutionalism was a really distinct school of thought. And because it was also being engaged in by people who were engaged in political action, where the Garrisonians were against political action, and so they really in somewhat stark opposition to each other. And it begins it might not begin there, but it really gets going in the 1830s, which is a long time before the period that you're talking about. And one of the signal leaders of this particular movement is Salmon Chase. Who's gotten, a lot of, in Freedom National, he gets a proper due. He gets somewhat a due in Team of Rivals to some degree. But he's the guy. He's kind of the thinker, among many others. But he was one of the more prominent ones who are pushing this abolitionist constitutionalism. And that term itself was a term that was in use to distinguish themselves from these other anti-political abolitionists. And so what that leads to is what I think is what we might call Republican constitutionalism, because it is actually the platform of the Republican Party, which was first the Free Soil Party, and before that it was the Liberty Party, all of which Chase was the person behind writing the legal part of the platform. And so there's actually a very long, robust work and really well worked out constitutional theory, not just positions, but theory that underlies all this, and it is responsible in part for the phenomenon of all these politicians basically playing off the same page. It's not just, they're just not randomly reaching similar results. They're reaching similar results because they're working through a pretty robust framework that's been worked out over 20 years. And now the results of this framework are all kind of converging on same outcomes, even where politically they find it uncomfortable. So they may have to dummy up because they don't want to admit. But what they don't want to admit is the logical implications of this deeper philosophy that their opponents well recognize. So I just think my only comment here is that to contextualize this still farther, we have to start looking at least in the 1830s to see this develop all the way up and through until it's finally abandoned or betrayed or whatever you want to say it is in the slaughterhouse cases, and then immediately after that. So you have a 40-year robust development that your treatment fits really, really well into, like Mike's does.
It's a suggestion about what the effects of robustly developed constitutional theories can have in the future. Do you have a quick response, David?
Yeah, just very briefly. With respect to Chris's comment, when wrestling with the antebellum evidence, I'm finding equalities, but perhaps not a sort of indiscriminate general principle of equality. And it's the equalities themselves are not distinct from, but are part of the catalog of fundamental privileges of citizenship. Exemption from alien duties, special taxes, special burdens on property. That's something that's an ancient privilege from the Roman Republic, and it's something that Blackstone speaks about, and it's in the list of Corfield, it's in the list of Campbell. A second form of equality is this marital right, and that also, I think, has a connection with citizenship. Now, that first category is actually fairly broad. I think it includes basically much of the black codes in 1865 are violated by the principle that you don't impose a kind of special taxes or special burdens on a portion of the community in a way that basically says you're not a part of the community. With respect to the education issue, and Michael McConnell's work, the one thing I would say is education is newer. Broad public education is newer. Marriage is not. So that the evidence is less. I did find a few things which, a few things of people saying that, well, this would include the right to go to the same school and things. But the evidence is less. You have to make more inferences from the evidence to say that equal citizenship would prohibit racially segregated schools. As to Bingham's original proposal in response to Earl's comment, Rogers of New Jersey did focus on the Privileges and Immunities Clause there. He said that it would bring intermarriage. Oh, you're talking about Republicans. Okay, yeah, sorry. So that that resolves that problem. And finally, I just wanted to mention something because I may never publish this stuff, and I've sent this draft to some of you by email, but in case I drop dead today, 3 bits of evidence as to this Republican, not just abolitionist theory of privileges and immunities of citizens that have not been largely looked at, which are obviously very important. The supplemental resolution introduced by Joshua Giddings, who was Bingham's mentor at the Republican Convention of 1860, indicates, and it was unanimously adopted by the convention, says that there's a right to travel and opinion and that the Democrats had been violating the Privileges and Immunities Clause by not allowing people to travel with their opinions. The second thing is the many compromise proposals in the winter of 1860 to 61, especially at the Washington Peace Conference, which proposed, among other things, a Privileges and Immunities Clause. And there's a significant discussion there which indicates that Republicans were interested in right to travel and freedom of community speech. And lastly, the comment in Lincoln's first inaugural address, where he says Congress ought to enforce the Privileges and Immunities Clause, plainly with reference to this Republican complaint. So I've seen only a handful. Avens has a comment about one of these things in an article in the 60s, but for the most part, this has not been looked at. And I just mention it that in future work on developing the Privileges and Immunities Clause and the Republican, you can see much more mainstream than, say, Joel Tiffany, or, well, Salmon Chase, to support the idea that the Republican Party had come to, by the eve of the Civil War, to a different theory of privileges and immunities of citizenship.
My second trinity, no less holy than the first, is Ilya Somin, Mike Rappaport, and Will Baud. Ilya.
So first, I'd like a lot of people like to commend the thoroughness and impressive nature of this paper in many respects. I have one very small point and one bigger one. The small one is that you mentioned Chief Justice Taney's discussion of this in the Dred Scott case, where he said, well, this is one indicator that blacks could not be citizens, even free blacks, that they couldn't intermarry. But I don't think he discussed, or maybe I just missed this, in which case I apologize, but I don't think he discussed Justice Curtis's treatment of this in his dissent, where he says, no, this is just one of many situations where you can be a citizen even though you're discriminated against in various ways relative to other citizens. I think that's perhaps worth noting, because I think at the very least, Curtis's view was one that a lot of mainstream members of the legal establishment had, may have been much more common than even the view that Taney had. He mentioned that Taney's view in many ways went against the mainstream. I just think that's probably right. My bigger point is about the question of, to the extent that this is an exercise in relating this evidence to originalist theory, sort of what version of originalism you're relating it to, in that in the paper I presented a couple years ago at the same forum, I talked about how there's a disagreement even among original meaning originalists about whose understanding of the original meaning at the time is the one that's relevant. And one thing that I tried to put my finger on is that there's a disagreement between people who think that the relevant audience is the general public or the reasonable speaker of English versus people who, the reasonable speaker of English at the time, versus people who think that the relevant reasonable person is somebody who's highly knowledgeable about the law, who knows what the legal elite knows. And I think this disagreement is very relevant to your project, and that I suspect that, I don't know this for sure, you know the evidence better than I do, much better, but I suspect that what was understood by these Republican legal elites may not have been understood by the average person. It doesn't, the idea that this covers interracial marriage doesn't leap off the page to a person who's not an expert reader. And I would also bet that Republican legal elites on average were more racially egalitarian than the median voter, even the median voter in the North. This may not be important to you if you're willing to endorse the view advanced by Gary Lawson and others that what matters is the reasonable person who knows a lot about legal text and the like and what they thought. But if you endorse what I think is actually the more common view, which is either the actual understanding of the general public at the time or the understanding by somebody who's a hypothetical reasonable speaker of English but not necessarily one that's highly trained in legal materials, then I think this is significant. You do, I noticed, cite some evidence about the understanding by the general public, but I think it's much thinner than the evidence, and it doesn't fully persuade me because the evidence that you cite is evidence of some newspaper accounts and the like, but we know from lots of survey data that there are things that are in the newspapers about politics all the time that the average voter does not know, and that could well have been the case in 1868 or 1870 just as much as it is the case today. So obviously I have the bias many have, well, what you didn't include is something from my work, right? All academics are always saying that, but I think this particular thing that I looked at may at least be somewhat relevant to your argument, depending on what direction you want to push it in.
Mike.
Okay, so 2 points. I mean, to preface it, I should also say that I like this paper quite a bit. So first, kind of a semi-response to Jack, when Jack says that, under my view, the idea that interracial marriage would be constitutionalized needed to be understood by a supermajority of the people in order for us to think it needs to be enforced. And that's not quite my view. My view is that you look at the original meaning of the provision as understood through, original methods, but you make a determination on that. There may be close cases, ones which people didn't know about, but you apply the original meaning. So there's no requirement that everyone understand all aspects of it. I think you may be bringing in a different point, which is Jack suggests that, well, how will we ever get anything that has determinate meaning if we have supermajority requirements? The enactors will just punt on everything, and then it'll be delegations to the future. And the point is that doesn't have to be the case at all when you have provisions like the original Bill of Rights, which were largely accepted by everyone, and they were just stating what everyone agreed on in the most part. Those things can pass with a supermajority without much problem. In the area of the 14th Amendment, obviously, we've always got special case here. The amendment is doing a lot more. It's reform legislation. It's legislation, or it's an enactment by the Republicans for a variety of reasons, and so different circumstances apply. So that's sort of point one. Point two, I may misunderstand this, and I'm not sure it matters so much for the thesis of the paper, but I guess I have a different understanding of privilege or immunity of citizenship, in the sense that I think David is saying that if a right is enjoyed as a matter of right by aliens, then it is not a privilege or immunity of citizenship. And I sort of puzzle about that, because if privilege or immunity of citizenship is the key rights protecting provision, and the core rights would be ones, the most core rights would be the ones that both aliens and citizens enjoy, the consequence of that would be that privilege or immunities of citizenship would not cover the very most core rights. And I find that to be puzzling.
Will.
I joined the chorus of thinking this is a great and impressive paper. I guess my question is, for David, I'm trying to get a sense of under your theory of the privileges or immunities clause, like how much it's about race and where the race comes in. Because sometimes, I take it, in your list of catalogs, there are versions of the theory that you could have that I take it you don't. Like, privileges or immunities means no racial discrimination with respect to common law privileges or immunities, and no things that are like racial discrimination, because those would be caste-like. And then we have to fight about what counts as like, and I think that's not your view. I think your view is more like, for a lot of the areas where this comes up, the kind of common law right itself was race neutral, and the race discrimination was introduced by positive legislation the legislation was in derogation of the common law, so we don't count it. But then I wonder, is that true for all other kinds of legislation that discriminated amongst common law rights? So if people impose statutes of limitations on common law rights, that didn't have them before? Would that be a derogation of the common law right and now gone? Would property tax? I mean, so there's like a whole list of like, is this a sort of, so it gets into the question of what's the role of the common law. But at a kind of a fundamental puzzle I always have in these 14th Amendment papers is since the 14th Amendment, since Section 1 and Section 5 don't talk about race, but obviously somehow race ends up being the key moving variable. I guess I just like your theory of like where and when race comes into it.
Very quickly, under the Equal Protection Clause, insofar as the government is doing the protective function, all human beings enjoy this equally. Old, young, pretty, ugly, fat, short, thin. So it effectively covers any form of discrimination that, as it were, declares open season on someone's person and property, provided they're within the state's jurisdiction. As for privileges and immunities, again, if you focus on the qualification citizenship, a statute of limitations isn't saying to a part of the community, you're not a member anymore. The problem with racial discrimination, why it almost always, maybe always, I don't know. I'm reluctant to go into the colorblind constitution because I think the evidence is vague on this. But the problem with racial discrimination, it is pretty much a proxy for non-membership because it's a hereditary group of people. And insofar as citizenship is defined both by place of birth but also by one's parents, to put a race discrimination in is effectively to put a kind of alienage label on people. So it comes in that way with again with kind of a focus of citizenship. As a practical matter, obviously lots of people are talking about this, and I don't want to exaggerate the degree to which, and maybe I'm disagreeing with Randy on this, the degree to which they really pound out and think out all these things. As I had an email with Kurt Lash about this. One thing that drives me absolutely nuts is the ways in which the evidence at the time they'll say, Section 1 covers it. It's an indiscriminate Section 1, like in Strada versus West Virginia. They quote the whole thing and say, what is this? But say we should have equal rights. I'm like, no, come on, guys, help me out a little bit. Can you split the things up and say what's equal protection, what's due process, privileges, immunities? And this happens through the ratification debates. It's just, and in part because Section 1 wasn't, in some respects, the most controversial part of 14th Amendment, which is another thing that's just really frustrating because they just don't talk about it as much. As to Ilya's remark, that's right about Curtis's opinion, and I think it's generally right about Northern Democrats in general. They have an interstate equality reading only of the 14th Amendment. The article that I haven't published actually says there are basically three. There's a pro-slavery absolute rights. There's a Northern Democratic right, which ultimately goes Lemon to Paul versus Virginia to Slaughterhouse, which wins the day. And then there's the Republican absolute rights reading on the eve of the Civil War.
You need to publish this article.
Okay. But as for what version, I'm inclined to say the important understanding is the understanding of the persons who were or likely to be the representatives of the people. And that is because our Constitution, Article 5, and in fact our entire Republic from the Declaration of Independence, presupposes, among other things, that the people are sovereign and that certain institutions are genuinely representative of the people. They're not across, they don't have the average education, as you said. I can say with almost dogmatic certitude, if you were to ask the man on the street in New York at any time in American history, what does due process of law mean? They're going to look at you and say, I have no idea what you're talking about. And that's, frankly, I don't think that's any particular insult to them. The reality is they're probably doing more important things than what we're doing. The same thing with privileges and immunity citizens. So I don't think you have any original understanding. With certain things, maybe you say cruel and unusual, people would say, isn't that kind of like you can't torture kids to death? But so you might get some of the clauses. But a lot of the Constitution depends upon, from the beginning, the idea that the people's sovereignty is mediated through representatives. So I am heavily focused on the actual representatives, people in Congress, people in the state legislatures, to the extent to which I can, or people that are likely to be like them. Mainly because you can kind of impute the same kind of opinions to the legislators if you can find them in someone like Horace Greeley's writings. And lastly, the privileges of citizenship. This goes to the last comment I made. The more we forget that aliens could not enjoy the right to own land in the United States, the more we forget that, again, as a matter of right, for instance, to get a patent in the United States, the 1793 Act said you had to be a citizen. And I looked at the debates, initially it said person, 1793 it said you have to be a citizen of the United States to get a patent. Nobody batted an eyelash. Now, as the 19th century progresses, aliens, first they get like a second-class citizenship, if you will. And now we have this kind of idea that the United States intellectual property is open for the entire world. From the founders' perspective, well, in the 19th century, the intellectual property, the right to engage in that kind of activity could be something that could be reserved to the citizenry. So the more you recover that sense, the thicker the Privileges and Immunities Clause gets. The more you just think in terms of contemporary categories, the terms themselves have to just pay no attention to that word privileged citizenship, because it won't mean anything. But this gets to just one other bit of evidence, just with reference to Joel Tiffany, and also the broader debate over privileges and immunities. In Joel Tiffany's enumeration of the Bill of Rights, as in Jacob Howard's, the religion clauses are conspicuously omitted in a way that suggests they're deliberately taken out. We also see this in the Blaine Amendment debates. The best evidence for incorporation is about freedom of speech. The worst evidence is about freedom of religion. I think if you pay attention to citizenship and the American tradition, you can understand why the religion clauses aren't going to be included, but why freedom of speech, petition, assembly, arms are included.
You actually quote, I think in the paper, one court, contemporary 19th century court, writing that the lawyers in the case, counsel in the case, didn't help us about which provision of Section 1 applies in that case, so that you're not the only one who's frustrated. It must have been pretty mortifying to counsel in that case, but they're presumably no longer with us. The next trinity is Thomas Colby, Larry Solem, and John Harrison. Thomas?
I want to add, first of all, to the chorus of people praising the paper, and I want to do it in a slightly more concrete way. I actually read your paper earlier this week, the night before I was going to teach loving, and I stayed up until after midnight revising my loving notes for the first time in about 10 years. So that's something, I hope. My question is actually relatively short and sweet. What business does the Privileges or Immunities Clause do here? And what work is it doing in the sense that if antebellum people are saying, if you make black people citizens, they'll have the right to intermarry. And then the first clause of the 14th Amendment makes everyone who's born in America a citizen, including those who are African American. Doesn't that do all the work right there? Why do we need the Privileges and Immunities Clause? I'm just curious about that.
Larry.
Great paper. Two suggestions. Sort of one suggestion is about the theoretical disagreement, and it is, insofar as possible in a paper like this, I think you want to take an ecumenical stance, right? And I think it would be nice if you did that explicitly. That is, if you tried to frame your argument in such a way that it could be embraced by originalists who are intentionalists and public meaning people and original methods people and so on. Second suggestion is I think it would really help to clarify this passage on page 17. This is the working hypothesis passage. I think that the paper is very strong on the on sort of the privileges of citizenship side, right? That's the strength of the paper, and that part of the paper is extraordinarily convincing, I think, in many ways. But I think the part of the paper that's underdeveloped is the of the United States part, right? And you have here a very, very fast two moves that you make. The first move is to say that they're the privileges or immunities that were common to all the states, right? And then the second part is sort of to leverage Article 4, and there's just a lot of dispute about both pieces of that definition. I understand you don't want to fully enter into those debates, right? Obviously, you have to, you have sort of many opponents here, right? But just to take people who are sitting close to me, right? On the one hand, you've sort of got Kurt, right? The privileges and immunities of citizens of the United States is a phrase of art, and it would be thinner than the suggestion you make here. And on the other hand, you have Randy, right, who has a much different and thicker conception of privileges or immunities of the United States. There's nothing in the paper to fend these people off. And your just statement of your position is so quick and so thin that it doesn't really give the reader who's not maybe fully immersed in this stuff with adequate notice and warning of how controversial this part is.
Well, this is not only great, but also important. And what I want to ask about is related to what Larry was just talking about, because I think there's an ecumenical version of this that's about racial endogamy and not just about the Privileges or Immunities Clause, and that doesn't have to take a position on some of the fine debates about exactly what the Privileges or Immunities Clause meant, and in particular whether the privileges or immunities of citizens of the United States include only some nationally uniform body of civil rights or also refer to state-by-state rights of state citizenship. And if it's only the nationally uniform part, and if that's what's going to do everything that the Privileges or Immunities Clause does, then I think you can't literally mean the part about the common law, because by the time of the 14th Amendment, the United States had a civil law jurisdiction. And it varied in some important respects, specifically with respect to the rights of marriage. Community property isn't the same as common law property. Forced heirship's not the same as freedom of testation. So if you want to have a body of private law rights, and in particular sort of marriage-related rights that are nationally uniform, they can't be either the common law or the civil law, and have to be something, I guess, one level of abstraction up. And whether any such body of rights of citizens that can include both the civil law and the common law ever existed or is something that the Constitution could refer to, I think is a tricky question.
Let me just say about the various theories with which I've wrestled in my doctoral dissertation. There is lots of evidence. There's so much evidence. And there's almost all the theories, as far as I can tell, have their favorite quotes and have substantial something. I mean, they wouldn't continue to exist if there had not been something that would support them. And I just want to say that as a preliminary matter, my disagreement on it. And one of the difficulties in getting into the weeds is because I did think that if Kurt's theory is correct, the evidence that it's the rights that are slaughterhouse is right, properly understood, that it's going to be very difficult to get this any kind of marital rights at all. And besides the fact that I think the preponderance of evidence, maybe even strong preponderance of evidence, is that Article 4 was intended to be enforced rather than some other privileges. As what Larry was saying about what type of originalism you're going to do, I was thinking about doing that. The truth is, I figured that no matter what, all the theories of originalism could find something nice here. It wasn't because you have people saying this is what we're going to do, intent. You have people of different sorts meaning it. The terms themselves can do. So I probably would include a paragraph on that, because obviously the word original is in the title. So it's going to attract people's minds to think, well, he's going to talk about originalism, so I should just simply say, which I am. I'm fairly agnostic as to the different forms of originalism. Let's see. Ecumenical version. I think I've covered all the points. Or at least I said all the things I'd like to say. Oh, the common law. You know,
This would be the Stanley Kowalski objection. In Louisiana, we got a thing here called the civil law.
Yeah. Yeah, obviously enormously complicated, and because of the changes that happened between the early 19th century and the mid-19th century in the common law, the ongoing contraction of the category privileges of citizenship. Many state constitutions are saying aliens as well as citizens have a right to own land here. We're going to abolish that distinction. And I'm inclined to say that the authors of the 14th Amendment were antiquarians, much as they were neo-feudal in their definition of citizenship, birthright citizenship. Again, when I say they are, maybe even just 40% of the evidence, maybe not even over 50%. But you've got the Corfelian standard, which is looking toward the customs, or the broad customs broadly understood of the American people from the founding era until the great perversion of the system from 1830 to 1866. From the standpoint of many Republicans, there's something bad happened either in 1828, that's Lincoln's start, or 1833, or in the response to abolitionism, which created a different republic and the states departed from the old ways. The objection wasn't entirely to obviously it wasn't really a departure from the common law, but it was a departure to sort of the principles of the common law. I'm not sure if I'm answering what you're saying, but yeah, it's difficult to deal with the evidence because of the complexities and the changes in the United States in the several decades before the 14th Amendment.
I fear we're out of time. I had possibly Mitch on the queue, though I wasn't sure if Mitch put it on the, or whether Jack was putting him on the queue.
I thought that we had a recognition some time ago, but it was my mistake,
Why
evidently.
don't you call him Mitch now, because I think Mitch has something he wants to say.
Mitch.
Lots of people have things they want to say. I don't want
Got room for one more.
Okay, I'm going to exploit that. Thanks so much. Great paper. Very quickly, a different point that has been made. Page 3. I don't love your characterization of the argument against originalism through loving. I don't think it works quite the way you claim it does. So you say, this critique of originalism seemingly rests on two premises. That a theory of our Constitution is seriously, if not fatally flawed, if it can't, let's say, account for the correctness of loving. And second, that originalism can't yield such a prohibition. And you say the first premise demands too much. But you then characterize that first premise as a premise about perfect constitutionalism. You characterize that as the view that that first premise must follow from a yet more general premise that says all that is just and good in the world the Constitution must require. That needn't be the premise that your opponents are assuming. So take Jack's comment to conclude his remarks. He said, you got me at hello. We all agree that loving is right. We think that loving got the law right. But that doesn't mean that that falls out of a yet more general premise that because loving is just, it must be right because, generally speaking, the Constitution requires everything that's just. Similarly, the second premise need not be as strong as originalism cannot account for loving. The view could be we have a very strong commitment to the proposition that loving is correct as a matter of law. And our commitment to that proposition is not contingent upon certain facts about the middle of the 19th century that we don't yet know fully. Many of us believe loving is correct regardless of how the history turns out, right? So it's a claim about originalism makes it contingent upon things, and we don't think it's contingent. So this is sort of the reflective equilibrium point that Larry and I have gone about. We don't yet know the determinants of our law. And when we figure that out, it's partly going to be a matter of reflective equilibrium, and we're going to draw upon other propositions that we have a high degree of confidence in. We have a high degree of confidence in the correctness of loving. That's the non-originalist criticism of originalism through loving, I think.
Well, if Jack brought Mitch in, I was going to be tempted to bring Kurt in as well, but we're out of time.
Well, wait a second, what was the point of mentioning it then?
Just, a slight nastiness on my part. Let me just iterate once again, I think for myself as well, what a fantastic paper this was, and a fascinating one. Not only the text, but the notes as well are just full of extraordinary stories. And at one point, the one criticism I think I have of the paper is that at one point, David tells a quite haunting story in one of the footnotes, and then sends a note to the editors, potential editors of the piece, saying, you might want to drop this. And I certainly hope they don't, and don't take his advice there. So, David, thank you hugely. Jack.